Okay, good morning, everyone. If you'll take your seats, we'll get started. Okay, great. Good morning. It is Tuesday, August 7th. I want to welcome you all to our Board of County Commission meeting for land use. And we're going to start with the Pledge of Allegiance and our prayer from our chaplain, Commissioner Stacy White.
Thank you, Madam Chair. We'll begin with the Pledge of Allegiance. Attention, salute, pledge. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Heavenly Father, as we make important decisions this morning about one of the most valuable resources that you've given us in our land, we pray that you will guide this board, and our staff, and our stakeholders. Lord, I hope at the end of this, we'll all remember that although we may be on opposite sides of some issues, that we have friends and neighbors in the room, and hope that you'll see to it that we can all come together at the end of this democratic process. As always, Lord, I pray that you will be with members of our armed forces and our first responders and guide them each and every day in what they do and bring them comfort and deliver them home safely. I ask for all of these blessings in your heavenly name. Amen.
Thank you. Thank you, Commissioner White. And we will now move to changes in the agenda. Mr. Moretta.
Good morning, Commissioners. Joe Moretta, Development Services Department for the record. We have 3 changes to the agenda. I'll read them into the record now. The first one is found on agenda page 10, item G-02, major modification 18584. The applicant has requested a remand of the September 17th zoning hearing master hearing starting at 6 p.m. And there's also a related vacating item which should reference V18. It inadvertently references V17-0017. That's Big Ben Storage, LLC. Staff has requested this item be continued to the November 14th, 2018 board meeting starting at 9 a.m. and that will allow both those items to arrive at the board at the same time. If you recall, at the last board meeting, these were sent back and they were asked to be heard together. So that will organize these cases so they'll arrive back at the board together. On the third change is agenda page 12, item H2B, major modification 18-582. Actually, I misspoke. Item 2 and 3 are going to arrive back at the board together, not items 1 and 2. This is the Decobo Corporation, major modification 18-582. The applicant has requested a remand of the September 17th zoning hearing master meeting. Because of that, items 3 and 2 will arrive back at the board together, allow them to be heard. One's a vacating and one is a major modification. If you recall, these were both at the board at the last agenda 2 weeks ago. So that takes care of the changes on to the agenda. Now we'll move the actual withdrawal, continuances, and remands on the agenda. Item A1, this application is out of order, is being continued to September 11th board meeting starting at 9 a.m. Item A2, personal appearance 18-998. This application is also out of order, is being continued to September 11th meeting starting at 9 a.m. Item A3, PRS 18-1000. This application is out of order, being continued to September 11th board meeting starting at 9 a.m. Item A4, personal appearance 18-1002. This application is out of order, is being continued to September 11th board meeting starting at 9 a.m. Item A5, personal appearance 18-1074. This application is out of order, is being continued to September 11th board meeting starting at 9 a.m. And that concludes all the changes to the agenda. Thank you.
Okay, may I have a motion to for the changes? We have a motion by Commissioner White, seconded by Commissioner Kemp, to approve the changes to the agenda. Please record your vote. Nope. Mine's not working. Can you, okay, now? There we go.
Motion carried 7-0.
And now if I can have a motion to approve the consent agenda. So motion by Commissioner Kemp, seconded by Commissioner Miller to approve the consent agenda. Is there any further discussion or questions? Seeing none, please record your vote.
Motion carried 6-1. Commissioner White voted no.
Okay, okay, anyone that has a B item on the agenda, your items have been approved. Now, those that intend to present testimony, evidence, or to otherwise be heard on any matter scheduled for consideration at today's meeting, please stand, raise your right hand so the clerk may swear you in.
Good morning. Do you swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth? Thank you.
Great. Now we're on the agenda. Mr. Moretta, first item.
First item is C1. This is a vacating. It's a public hearing, vacating petition V18-0019. Ms. Alicia Alvarez will present this item for the Real Estate Department and be available for questions.
Good morning, everyone. Good morning, Commissioners. For the record, Alicia Alvarez, Real Estate Facility Services. Item C1 today, vacate ID V18-0019. This petition is being brought by Christopher D. Valle and Athena D. Valle to vacate a portion of a platted 7.5-foot wide utility easement within Lot 16, Block 4, within the plat of Baycrest, Park Unit number 16, as recorded in Plat Book 41, page 16 of the Public Records of Hillsborough County. This petition request is made for the purpose of rebuilding an existing pool enclosure which was damaged by Hurricane Irma. The subject area is located on the south side of Lava Place, west of Lopez Drive, in the Baycrest area of Tampa. The petition was routed to appropriate departments and agencies, and there were no objections to the vacation of the portion of this utility easement. The staff recommends approval of this petition request.
Great. Thank you for that explanation. And this is a public hearing. Is there anyone here wishing to speak in favor of item C1? Anyone here to speak in opposition to item C1? Okay, we'll close the public hearing. A motion by Commissioner White, seconded by Commissioner Kemp to approve item C1. Is there any further discussion? Seeing none, please record your vote.
Motion carried 7-0.
Okay, we're now on the E items.
Thank you, Commissioners. Item E1 is a public hearing. Personal appearance -18-0851, located in the Ruskin area on the south side of 16th Avenue, southeast of 12th Street. Commissioners, this is a small change to an existing plan development that was approved in 2004. There was an area within that plan development that had a road connection. That area required the applicant, not required by regulation, but the area was planned for a purchase to basically have an outcome of a roadway that was internal to the site. That roadway area could not be purchased, so that is being removed from the plan. It has no bearing in terms of the design guidelines. It still meets the design guidelines for the Ruskin area, and it has no bearing on the regulations in terms of how we arrived at the original approval of the site. So it's a minor change, and the applicant is also adding in 11 lots to the maximum from 373 to 384, and it really has no significant change on the overall design of the plan, so we are recommending approval with conditions.
Okay, thank you very much. The applicant here. Good morning.
Good morning. William Malloy, 325 South Boulevard. As Mr. Moretta said, this is really just a cleanup of an existing PD plan. We're adding a handful of units and deleting one access point, which was extraneous. And I'm happy to answer any questions about that.
Okay, I don't see any questions right now. We'll just move right to the public hearing. This is a public hearing. Is there anyone here wishing to speak in favor of item E1? Anyone wishing to speak in opposition to item E1? Okay, close the public hearing. Board action, motion by Commissioner Kemp, seconded by Commissioner White and Chris. Is there any further discussion? Seeing none, please record your vote.
Motion carried 7-0.
Okay, next item.
Thank you, Commissioners. This brings us to item E2, personal appearance 18-0977, located on the southeast quadrant of 10th Street Southwest and Woodland Estates Avenue in Ruskin. Plan development was approved in 2006. Commissioners, the original plan development had a campus-style development plan. Within that plan, there was a condition that required a public easement for sidewalk dedication, had multiple buildings, and the easement was going to serve to be a pedestrian walkway to connect all the buildings. This modification proposes to eliminate the campus style, allocate that commercial entitlement into a single building. They're reducing those entitlements from 21,950 to 11,000 square feet of CG uses. Because of that, they're asking for the elimination of that condition because it's not really relevant to the design that they're proposing in a single building versus multiple buildings. They're also asking for other conditions to be modified to enable the plan of development as proposed, dealing with access, and they're going to default to the code in terms of our code requirements that are required of all commercial development for sidewalks. Staff has reviewed this, and we are recommending approval with conditions.
Okay, thank you very much for the explanation. Is the applicant here? Good morning.
Good morning. My name is Paul Crochet. I'm an attorney at the law firm Weber, Crabb & Wien in St. Pete, and I represent the owners, Mr. Robert Brower and Lisa Maurer. The owners have been working quite extensively with staff to make these changes, and it's really based on the change in use of the property. It was formerly going to be a sort of a woodworking place where there would be other retail type facilities that would allow for the public to walk through the project, and because we're changing that to an event center, really a place where people can get married. The use is completely different, and that's really the basis for the change. I have the owners here as well as the engineer, Chris Grasso, so if there's any questions, please feel free to ask.
Okay, I don't see any questions right now, and they're welcome to speak in the public hearing if they'd like. We are on item E2, and we'll open the public hearing. Is there anyone here wishing to speak in favor of item E2? Anyone here to speak in opposition to item E2? Okay, we'll close public hearing. Board action. Motion by Commissioner Kemp, seconded by Commissioner Miller for item E2. Is there any further discussion? Seeing none, please record your vote.
Motion carried 7-0.
Thank you. Item E3.
Item E3 is personal appearance 18-1010. This is a proposal for multiple lots within plan development 17-0619, located on the north side, north of Ambleside Road and west of Tanya Ann Drive in Riverview. Commissioners, this is a request that is to amend a setback that's specifically applicable to a garage on the facade, the front facade of a home. It requires a 25-foot setback for subject lots. Within this PD, there's 48 lots that are dispersed throughout the PD that are a subject of this application. They're requesting that that setback be consistent with the front yard setback for the remainder of their home. So it would bring the setback to 20 feet, which would be consistent across the entire front of the lot. Staff is recommending approval with conditions.
Okay, thank you very much. Is the applicant here? Good morning.
Yes, ma'am. Good morning again. William Malloy, 325 South Boulevard. This case is kind of unique in that we are coming to you and asking for a bit of forgiveness. There were some errors made in the application of the construction plans, in the approval, and then the construction itself. Approval today would clean all that up, and we very much ask for your support for that.
Okay, very good. Thank you. Don't see any questions. We'll move the public hearing on item E3. Is there anyone here wishing to speak in favor of item E3? Anyone here to speak in opposition to item E3? Okay, we'll close public hearing. Board action. Motion by Commissioner Kemp, seconded by Commissioner White to approve item E3. Is there any further discussion? Seeing none, please record your vote.
Motion carried 7-0.
Okay, we're now on the regular agenda. We have oral arguments, so I'll ask for a motion to open oral argument. Motion by Commissioner White, seconded by Commissioner Chris. Please record your vote to open oral argument.
Motion carried 7-0.
Okay.
Thank you,
Joe?
Commissioners. This is major modification 18-0561. It's located 12 feet southwest of the intersection of North and South Parsons Avenue and west of Old Hillsborough Avenue in the Sefner-Magno planning area. This site was originally zone plan development in 2006. The particular plan development allowed for a total of 16 lots, typically RSC4 standards, which are quarter-acre lots. The application is to ask for increased density in terms of number of lots. They're asking to go to 30 lots, minimum lot size standard of 6,600 square feet. They've also made some adjustments to the site plan on the easterly side to increase the setbacks along those sides on recognition of larger lots. The gross density is 3.2. The comp plan density is 4. This is in the urban service area. They are proposing to up the density in this area. There are immediately surrounding larger lots. There's an emerging development pattern in the area, however, that we recognize as being suburban. That in context with the urban service area as part of our review, we are recommending approval because of those factors, and we have recommended approval with conditions. We're available for questions as needed.
Thank you very much for that explanation. Is the applicant here? Good morning.
Good morning. Vin Marchetti, representing Highland Homes on this zoning application. Joe did an excellent job explaining the request, and again, the location of the site as well at Parsons and Old Hillsborough Avenue. Joe mentioned the reduction and the increase in lot sizes or lots from 16 to 30 from the original lot sizes entitled in 2006. The feasibility of developing those lots from 2006 are really non-existent at this point in time, which is why you have the emerging trend in the area that David Smith's going to show you as well in a minute. David is going to review the site plan, explain our proposed buffering and screening in detail. Our traffic engineer, Mike Razor, is here. Our civil engineer, Todd Amman, is here as well. And also our Director of Land Development for Highland Homes, Milton Andrade, is also here to answer any questions you have. He did not file oral argument. His counterpart at Highland, George Lindsay, did file oral argument and did speak to the ZHM during the hearing. I'll be presenting his testimony today. I talked to Johanna about this. George could not be here today to present his testimony on his own. So let me have David go through his analysis first, then we'll go from there.
Okay, thank you very much.
Commissioners, David Smith, 401 East Jackson Street, Suite 2100. Planner with Stearns Weaver Miller. As indicated by Mr. Marchetti, this is a major modification to existing plan development, proposing 30 lots as opposed to the original 16 lots that were proposed. What we've done in the site plan is provided for a buffer along Parsons and Old Hillsborough Avenue that includes a landscaping strip that is not otherwise required to be provided along both road frontages. Sidewalks exist on Old Hillsborough Avenue. Actually, they exist all the way up to the school, and we'll be adding sidewalks on Parsons. We've increased the lot sizes around the perimeter of the development in order to be sensitive to the adjacent properties, and we knew there was concern with respect to compatibility, and a compatibility analysis is what I provided to you. This was submitted for the record. As we can see, this is the subject property. We have over 523 feet to the property that immediately butts us on the east, 168 feet to the home that is also just to our west. To our south, we have 186 feet from our property boundary. Parsons Avenue separates us from properties to the east. And to the north, there's a church facility that's educational facility that's 183 feet, also has an existing screen. This is generally providing for a transition, a buffering. There's also a pond that will be located here that provides additional separation. Looking at the area as a whole, this is a little harder to get on the Elmo. But as you can see, this particular piece of property, whoops, excuse me, this particular piece of property, yeah, I'll bend it down, thank you, shows that there are existing subdivisions of similar lot sizes that have been approved. This one's about 600 feet to our south. This is a new one approved just south of the library and park. This is directly up Parsons, and the surrounding area does have larger lots, but it's in the urban service area, and we provide for infill development, which is consistent with the community plan. We believe this project is consistent and compatible, as supported by the ZHM Planning Commission staff, as well as your development services staff. Here to answer any questions.
Okay, thank you. You have like 6 minutes left.
Okay, thanks. Again, Vin Marchetti for the record. Let me read the testimony that George Lindsay presented. Again, George is Vice President of Development for Highland Homes. He testified at the ZHM hearing, and again, he did file oral argument to present this testimony. And he did ask me to read the statement. This is verbatim from the page 151, and then I'll refer to page 178 of the transcript from that ZHM hearing. We, meaning Highland Homes, has been active in Hillsborough County for years. One of the most recent projects was just a quarter-mile north of here, that was referred to by Mr. Smith on the overhead there, has 27 lots. We're proposing 30 lots here. We have had the same lot size in that community and sold out in about 14 months. We will offer 8 to 12 different floor plans in this community, ranging from about 1,700 square feet to 2,900 square feet. We expect the same rate of absorption in this community. On page 178, I want to give you a brief profile of our buyers. And we do have a lot of new families, first-time home buyers moving into our communities. We also have single professionals, veterans, teachers, preachers, cops, and nurses, the workforce of Hillsborough County, providing them affordable housing. We have those who are downsizing their home but are still empty nesters, and we also have retirees. We have quite a mix of folks that make themselves available for home ownership, moving up, moving down, and those who are in the workforce in Hillsborough County. That was quoted from Mr. Lindsay. The staff recommendation for approval, Joe mentioned that earlier. Planning Commission also found this case to be consistent with the comprehensive plan and compatible. I want to read some of the findings of fact from the zoning hearing master, pages 11 and 12 of the ZHM recommendation specifically, in recommending approval of this petition with conditions which we agree to, by the way. First, also, I want to mention there's no objection from transportation staff, and also the fact that there's an increase in infrastructure in increasing the number of lots from 16 to 30 is minimal, according to the ZHM herself, as well as the utility department. She also found that the surrounding area includes a range of various lot sizes and that the applicant committed to larger lots on Parsons, and additional screening and setbacks result in, quote, the proposed major modification is consistent with the character of the neighborhood and the comprehensive plan, end quote. Ms. Finch concluded that there is, quote, substantial competent evidence to demonstrate that the requested major modification is in compliance with and applicable requirements of the LDC and with established principles of zoning law, end quote. We do have some opposition today, as we did at the ZHM hearing. The ZHM did hear that opposition testimony very well, very clearly. She reiterated within her report the testimony provided by those in opposition. She also considered the case very carefully and rendered the 13-page recommendation before you today. Thank you.
Okay, you have 2.5 minutes left?
I'm done.
You're done?
Thanks. Yep.
Okay. Actually, could I get you to go over and move that timer around on the thing so the speakers can,
Sure.
Neil have to do it, Ben. Thank you. Okay, we'll now go into the oral argument and remind everyone that you are limited to any findings that came before the zoning hearing master. So is there anyone here to speak in favor of the item G1 that has not spoken so far? Dennis Carlton, Tom Amadon, they're not here. There are other speakers to speak in favor. Oh, okay, thank you. Okay, we now have the opposition, Elizabeth Belcher, Herbert Belcher, Sandy Cooper are the first three speakers.
Hi,
You're
good
gonna
morning,
speak
County
on behalf?
Commissioners. My name is
Okay, you
Cheryl
have a total
Stanton.
of 10 minutes.
Okay, I've been asked to go first by the others.
Okay,
if that's okay.
good. What was your name?
Cheryl Stanton.
Okay, very good.
That's what you wanted.
Thank you.
Good morning, County Commissioners. My name is Cheryl Stanton. I live at 1001 Alta Drive in Seffner. I am before you today speaking on behalf of the Seffner Community Alliance and the surrounding neighbors. First, in the rezoning hearing, Mr. Marchetti stated in rebuttal at the rezoning hearing that many people that spoke in opposition do not live by the property. This is not true. We do live by the property. I am one street over. Sandy and Steve Cooper's property abuts this subject property, and they will be speaking also. There is no code that defines who can and cannot speak and how close you have to live to the property, but we are in the direct vicinity and we do drive past it every day.
Excuse me, may I interrupt just for a minute? I just wanted to ask the board to refrain from taking a look at this material until I've referred that it's acceptable based on being presented at the zoning hearing master.
Was this material presented?
All the pictures were presented. I have the proof in my folder.
The pictures plus the written?
Yes.
I mean,
Well,
everything
I don't
in
know if
here.
the written is the exact same, because I kind of got up and just kind of talked. If you want to just look at
That's
it.
the problem. We have to stick to exactly what came before the zoning hearing master.
Well, the pictures were.
Well, please,
Then we won't be able to look at it.
please send those booklets back
You
my
can show
way.
the pictures on the Elmo, though.
Yes, ma'am. You may take the
Okay,
binder
the pictures
and
are on the Elmo. I don't know if you guys can see the Elmo. Can you see the Elmo?
Yes.
Yes.
Uh-huh.
Okay.
We've got it. So we'll pass these back over. Thank you.
Okay. Mr. Marchetti also said that individuals who spoke in opposition can continue to maintain their lifestyle if they would like. This is not true, as building on these homes on small lots will impact our lifestyle by increasing traffic, limiting emergency services, changing the character of the community, and essentially eliminating the suburban lifestyle. This area is rural in appearance, and it is coded as suburban, not as urban. Also, he stated that we are generally not in favor of any development. This is also not true. We met with the owner about 10 years ago when she initially went from AR to the 15 lots. We agreed with that development and we did not oppose it. According to the unincorporated Hillsborough County Comprehensive Plan, this would not be in line with that plan. We would not be opposed to RSC-sized lots, but we are opposed to the small lot size. The goal of the comprehensive plan promotes choice of lifestyle for residents. The people that bought in this area chose a suburban lifestyle. Allowing this rezoning is changing a lifestyle to a more urban character and is in conflict with the comprehensive plan. A new development should not violate the rights of the existing homeowners. I'm quoting from a pamphlet published by the Planning Commission on the comprehensive plan. An urban service area was established as part of the long-range comprehensive plan. It focuses growth to a geographically defined area, which is planned for urban services rather than allowing growth to happen where there are few or no planned urban services in the near future. And within the urban service area, infrastructure zones will be established to encourage infill development to further maximize the use of existing infrastructure and create a logical extension of the established urban pattern. This is not part of the established urban pattern. Putting up a subdivision name sign and a few small trees does not make it compatible, and it does not transition just because there's trees and a small fence. It doesn't transition from large lots and acreage. It makes a giant step. It further states that the overall goal is to ensure that the quality of life for residents of Hillsborough County is not diminished as more people come to Hillsborough County. The urban services area also maintains the freedom of residents have to choose a variety of settings in which to live as the county's population continues to rise. The comprehensive plan targets 3 distinct lifestyles: rural, urban, and suburban, as desired for residents. That's from the comprehensive plan. This parcel is surrounded by parcels of land that are on 1, 2, and 5 acres. This is a rural area in appearance, and in order to comply with the comprehensive plan to maintain our quality of life, RC4 lot sizes should be used.
Excuse me. I'm sorry. I hate to interrupt, but these photos have some text on them that was not presented at the ZHM, so I would just ask you to please use the exact same photos that are in the ZHM exhibit record.
Okay, I thought when it said that we could use oral arguments to clarify ambiguities, that I could clarify, because the picture doesn't show what the acreage is.
We are quasi-judicial here, so we
Yes,
are
ma'am.
limited to all the material that was presented at the zoning hearing master and nothing more.
Okay, we'll keep the text down. Using a PD district within RC standards down is a gross misuse of the PD zoning and is shades of yesteryear. Repeating history of PD should not be recommended. Although I recognize that other subdivisions have gone in the area, we were not aware of them before they got passed and approved. And if residents don't take off from work and come down and oppose them, it seems that everything just gets approved. We work. I had to take off from work today to come down here and talk about this. And because of the notice requirements in our large parcel areas, we don't get notice when these things get put up because we're on 1 and 2 acre lots. So we don't even get notice on most of these. So the other ones that did get approved, we didn't know about till it was too late. Seffner is still transitioning into a suburban, and now while the transition and development is coming, the plan is forcing the elimination of the suburban lifestyle by requiring PDs to create smaller lot sizes. Again, we feel that this is out of character with the existing community. The request is for smaller lot sizes. It's going to increase our traffic. It will reduce emergency services. We have a unique flavor in Seffner. We're still rural. We have people that have goats, chickens, cows, horses, people that work in their shops doing woodworking or working on their hobby cars and their race cars. My neighbor has a race car that he keeps back in his backyard and has 5 acres. We're just asking for you to make it be RSC4 and not allow this smaller lot size. It is setting a precedent. It's increasing our traffic. It's changing our way of life. We do have a problem with flooding in the area also. It currently floods. I know they're going to put in a retention pond, but I know it already floods, and putting in concrete houses is not going to have it flood less. It's going to leave less soil to soak up the rainwater.
Excuse me again, I don't see that photo in the record from the ZHM exhibits.
I thought it was.
I want to just make sure that was previously in the record. I don't see it.
Are you sure?
That particular photo.
I thought it was.
And you only have 4 minutes
Okay.
left. I just
Let me just wrap up and let the other people speak then.
Well, I mean, you have only 4 minutes left.
Right, okay.
Okay.
I'm going to wrap up and let the
there's
others speak.
quite a few other
Right.
speakers that are signed up.
I know that, I know them. We beseech the county commissioners to deny this request for a major modification and begin supporting the suburban lifestyle that we chose. Thank you.
Okay, thank you. Good morning. And if you please identify yourself.
Yes, I'm Denise Verrill of 303 Lena Avenue in Seffner, and I would ask that everybody who's opposing...
You are not
Yes, I am.
a party of record? I don't have you on the list.
I spoke at the meeting.
The zoning
We
hearing
did not.
list?
We did not receive an oral argument request from Ms. Verrill. So even if she did speak at the zoning hearing master, you were also required to file for a request for oral argument with the clerk's office, as the others from the neighborhood did, in order to be able to speak at the board meeting today.
No, I did not do that. But I do feel like I should be heard because
You can't, ma'am, I'm sorry. We are
I can
limited
submit
by.
my written testimony then? Because I was at the meeting as the zoning hearing master.
Your testimony, ma'am, is already in the record from the zoning hearing master,
But
so the board members can refer to that as part of the record.
It's been summarized greatly in the report.
Ma'am, because you didn't sign up or request for oral argument, won't be
Okay.
able to present anything further
All right.
today, but I can assure you
I
that
oppose
you
it.
were
Thank
in the
you.
record.
I'm sorry. Good morning.
Yes, this is classic of what happens when people who are just ordinary citizens try to, Elizabeth Belcher, Seffner, Florida. Ordinary citizens just try to address the issues without having paid professionals up here who know all the details and all the little rules and everything. So just quickly, because we have...
Have you been sworn in?
Yes.
Have you been sworn in by the clerk?
What? No.
Okay.
If you want to just...
You all were, I mean, I'm just verifying that you were sworn in. Yeah. We just
Okay.
want to verify that everybody's been sworn in, because I saw different people come in and out.
Okay, now that we're eating up the clock, I just want to make
No,
one...
that did not take time off the clock.
Okay, I just want to make one little point and let somebody else speak. There was a comment made this morning about it is not financially feasible that they developed the property as it was initially allowed when we gave them rezoning privileges initially. So my statement is, because it's not financially feasible, that is the owner's problem, not the community's. It is not our responsibility, the community's responsibility, to make sure the outside developers make more of a profit to destroy our way of life. Thank you very much.
Thank you. Next speaker. Good morning.
Good morning. I'm Sandy Cooper. I live at 206 South Taylor Road in Seffner. I'd like everybody here in opposition to stand up that live in the area.
These are only those that could be here.
Sir, we can't have outbursts. Thank you.
The reason that we are here is because this land is precious to us. We've put our blood, sweat, and tears into this property. And we agree 16 houses would be sufficient on that property. But if you bring in 30 houses, which, by the way, Mr. Marchetti, does abut my property, the retention pond will be on the corner of my property. And I was at the land use hearing meeting, and he said there was nobody here that had any abutting property. But what I'm trying to say is when I walk out my back door, it is a peaceful area. And right now I can sit on my patio, enjoy the breeze, the noise factor, everything. You put 30 houses in the corner, I won't be able to sit on my back property. I won't be able to look at the horses that are rescued. We won't be able to go out in our front lawn because trees have been falling. The grounds are so saturated that the trees uproot. And I have pictures of that I cannot present, which you've made clear, but I will present at the next meetings that come up, because I'm sure if this development gets approved, then the other 3 developments in that area will be approved as well. And if that's done, then all the traffic for that area needs to be surveyed at one time, not just one area at a time. They need to do all 3 areas because it affects all 3 areas and it affects all of our lives in that area.
Thank you very much. And there's 1 minute left.
Yes, my name is Herbert Belcher,
Good
Seffner,
morning.
Florida. I have one issue and one issue only, and that's public transportation. The county has said that all housing, new housing being built, should be accessed for public transportation. These developments do not have any public transportation within 3 miles. Do you get that? Not within 3 miles. That's your policy, not anybody else's. The last item that you have to worry about is that. Thank you.
Thank you. And there are a few seconds left. Does anyone else wish to speak in opposition? Okay, and we'll now allow the rebuttal from the applicant. And you'll have 5 minutes.
Vim Marchetti in rebuttal. I'm going to have Todd hand out to you a graphic that was presented as part of the ZHM package, showing distances that people who had spoken that we knew about before the ZHM, showing how far they are from the site. David?
Commissioners, David Smith for the applicant. This graphic that was filed for the record just gives some reference. Number one is the speaker regarding the abutter, the only abutter. As you can see, it's the southwest corner of the property. Other speakers were a quarter mile, a mile away, and they do live in the area. But what I want to point out is that this is an RSC 6 style development, the minimum lot sizes, consistent with comprehensive plan, consistent with infill development, and will not have a negative effect on their ability to have their lifestyle on their larger lots, their workshops, or whatever they're doing today. This provides an alternative lifestyle in an urban service area where there are urban services. I'll yield to Mr. Marchetti.
Milton Andrade.
Have you been sworn in?
Yes.
Okay, great. Thank you.
Sorry. Milton Andrade, 14753 Scott Key Drive, representing the developer Highland Homes. Just to answer some of the questions as to exactly why we are moving forward with these smaller size lots. As my team spoke about the project further north that we developed, I believe, a couple of years ago, we found it to be a very successful project. We sold out, like they said, in 14 months. So we understand and we know that there is a demand, there is a need for smaller size lots in this area. There is the market for it. And in addition, through extensive site planning of this project, reducing the density to 16 lots is simply not cost feasible. Having to absorb the cost.
Excuse me. Just wanted to ask
Yes.
the board to please set aside that map while I'm confirming where that was in the record, the map from the applicant's representative.
Okay. So again.
Okay, can we just hold on a second till we get this cleared up? Then we'll let you proceed.
Sure.
Okay, let's not, the staff will figure it out. Is it, can you determine, is it on there?
Please proceed. I have located that map in the record.
Okay, thank you.
Okay, thank you.
Thank you. I'm
Again-
sorry
again-
for the time delay. It didn't take off time on the.
It's okay. It's okay. As I was saying, the project is simply not cost feasible with larger lots going down from the proposed 30 to what was previously approved at 16. Losing density that is needed to absorb the costs necessary to build the site to county standards, such as having a lift station, having off-site improvements, adding the perimeter screening, and off-site improvements. Thank you.
Okay, thank you.
Okay, thanks. Vin Marchetti again for the record. A couple of other comments. Then I want to have Todd, who's our civil engineer, wrap it up. You did see from the graphic, which was part of the record, that the vast majority of people that, I said vast, I said at the ZHM hearing, I didn't say that everyone who opposed it was away from the site, but the vast majority of people are significantly away from the parcel in question. But irrespective of that, it's a Res 4 land use category parcel. In the comprehensive plan, it's considered to be suburban land use at Res 4. 4 units per acre, we are seeking 3.2 units per acre. The policy in the comp plan is density of no less than 75% of your land use designation in the urban service area. This property is infill. It is exactly what this board has dictated in the comprehensive plan to be developed. The Planning Commission supported it from day one, as did ultimately the Development Services staff, with the buffer screening conditions which we agreed to, and also the increasing of lot sizes in certain areas of the site. There is no increase in traffic. It's so de minimis that transportation staff said no effect. There is no reduction in emergency services as a result of this application. That's simply not true. Look at your agency comments that were filed, and you'll see what I'm describing today. Of course, you have to base your decision on facts, not speculation. Ms. Belcher talked about process. I will tell you that I attend every one of the ZHM hearings. The county attorney sitting there does an excellent job explaining the process. Probably takes 5 to 7 minutes every single hearing. In the back of the room here, they have the forms of oral argument to be completed by those in opposition or those in support. It's very well discussed. So if someone missed it, it's not anyone's fault but themselves, honestly. Sandy Cooper said the land is precious to Ms. Cooper, I guess her family. If it's so precious, they can buy it. I mean, honestly, it's a situation where the landowner needs to have the site developed. My client has it under contract and can't develop it at 16 lots. 30 lots is the minimum, and that's what we're asking for. Let me have Todd just speak very, very quickly on drainage.
Okay, 20 seconds.
20 seconds.
Todd Amidon, Landmark Engineering, 8515 Palm River Road. As I stated to the hearing master, this project will have no stormwater impacts. Preliminary design calculations indicate that we're going to design a percolation pond to hold and retain the 100-year storm and won't have any impact on surrounding properties. Thank you.
Thank you very much. Okay, that concludes the oral argument. We'll now go to Planning Commission staff.
Thank you, Madam Chairman. Tony Garcia, Planning Commission staff. The proposed major modification to increase the allowable density in the existing plan development would allow a use compatible with the surrounding area, given that the subject property is surrounded by residential land uses in all directions. The currently approved plan development allows up to 16 single-family residential dwelling units, and the applicant is requesting to increase the allowable number of single-family residential dwelling units up to 30. The residential 4 future land use category allows consideration for up to 4 dwelling units per gross acre. With the subject property's 9.28 acres, the site can be considered for up to 36 dwelling units. The applicant is requesting up to 30, which is below the maximum that can be considered and is therefore consistent with the Res 4 future land use category. The applicant is requesting a density that is at least 75% of the allowable density of the future land use category, and therefore is consistent with policy 1.2 of the future land use element of the future of Hillsborough Comprehensive Plan for unincorporated Hillsborough County. The applicant is requesting a lot size minimum of 6,000 square feet with a 60-foot minimum lot width. Though the immediate vicinity surrounding the subject property contains single-family parcels that are larger in size, there are parcels in the nearby area that are smaller in size. The majority of the smaller lots are part of newer residential subdivisions. For instance, southeast of the subject property is a development along Diamond Ridge Road that includes platted lots ranging in size from 5,000 to 8,000 square feet. Directly south of that development is another single-family residential development that includes 7,000 square foot lots. The larger lots in the vicinity of the major modification area represent an older development pattern from a time when the area did not have access to public utilities. Now that services are available to the area, more infill residential development is occurring. While this situation is not unique to the Seffner-Mango area, it is consistent with the Seffner-Mango Community Plan. The comprehensive plan addresses compatibility in several of its policies, including Policy 1.4 of the future land use element. This policy outlines that compatibility does not mean the same as, rather it refers to the sensitivity of development proposals in maintaining the character of existing development. In addition, Objective 1 of the future land use element indicates that the majority of new growth in unincorporated Hillsborough County should be directed into the urban service area. The major modification being requested would meet that objective as the subject property is located in the urban service area. Based upon these findings of fact, the Planning Commission staff finds the proposed request consistent with the comprehensive plan. Thank you.
Okay, thank you very much. Zoning Hearing Master.
The zoning hearing master considered this proposed major modification to Plan Development 06-2235, which is currently approved for 16 residential lots with minimum lot sizes ranging between 11,000 and 14,374 square feet. Zoning hearing master explained that the purpose of the major modification is to request an increase in the number of lots from 16 to 30, and that additionally the modification proposes to reduce the minimum lot size, revise the required screening, and relocate the access point to the development. The zoning hearing master considered the testimony in opposition that was received at the hearing, and the testimony was found to primarily focus on the transportation issues in the area, stormwater drainage, and the compatibility of smaller lots in terms of appropriateness and their possible impact on existing home values. The zoning hearing master found that the impact of the increase in the number of dwelling units from the already approved 16 dwelling units to 30 dwelling units is minimal. The zoning hearing master explained that the developer has committed to mitigation techniques such as developing larger lots along Parsons Avenue, as well as increasing the required rear yard setbacks for the lots along both Parsons Avenue and Old Hillsborough Avenue, and providing a screening easement along the northern and eastern boundaries of the planned development to mitigate the potential impacts due to the change in lot sizes. The zoning hearing master found that the modification proposes to include zoning conditions consistent with both the Land Development Code and the Comprehensive Plan, and found that the recommendation found a recommendation for approval of the major modification to Plan Development 06-2235.
Okay, thank you very much. We'll now go into board discussion. Commissioner Hagan, you're recognized.
Thank you, Madam Chair. This is a classic example of the challenges we face and will continue to face in the future with the influx of 500,000 people expected to move to Hillsborough County. No one wants urban sprawl, and yet time and time again we have an infill project with full recommendations of approval, and unfortunately neighbors oppose the project. Well, we cannot afford to have it both ways. It's in the urban service area. There are multiple subdivisions in the area. They're proposing an increased buffer. Planning Commission found it consistent with the comprehensive plan. It has all recommendations of approval. Unfortunately, I see no legal basis to deny the project, so I'm going to move approval.
Okay, thank you. We have a motion to approve item G1. Do we have a second?
I'll second it.
Okay, a second by Commissioner Crest. Commissioner Miller, you're recognized.
Thank you, Madam Chair. I have a question of Mr. Moretti. Mr. Mokadi. Maybe I missed this, but did you meet with the citizens out there?
My client had some communication. I'm not sure exactly what they did, but I can ask Milton directly.
No, I want to know.
Okay, I'll ask Milton. No, Milton said no meetings with the residents.
So you had no meetings with the citizens to explain what was going on out there?
Well, the way the process works is we send the notices out.
I know how the process works.
if they ask for a meeting, we have the meeting. They did not ask for a meeting. So, and it's an infill project.
And the way you perceive that they should handle this property is to buy the property themselves in your statement that you made. Is that what you said?
No, what I'd said is that the person who spoke made a comment about how the land was so precious to her, and it's not her property. That's all I said. I didn't suggest that she buy it, but, you know, it's not her property.
So you, because the map you showed us, that the people live a certain distance away from this, your client felt that it was not feasible to go talk to the residents to at least have a conversation with them to see if we can work something out.
Let me have him address it because I wasn't.
Come up.
To answer your question, no, we didn't meet with the citizens, but we did follow the process of sending out the notices of what exactly the project entailed. As my team showed, there was only one adjacent property owner that had filed a complaint. Everything else was within a quarter mile away. We've met all county standards. We felt we were compatible with the site plan. So to answer your question.
Okay, so I understand the process. I'm just trying to see why is it that you probably knew, and I'm probably sure Mr. Marchetti knew, that there was going to probably be some opposition to this from those living even as far away as the map you showed us here. Correct. You could have had a meeting to talk to them to see if there was some possibility of working somehow some amenable solution that we can get through this. I understand what Commissioner Hagan just said. Yes. However, why did you not? I mean, just because you felt the process was taken care of and you didn't have to do it. Is that right?
We just felt like we met all county standards.
Okay, thank you.
Thank you.
Okay, you finished, Commissioner Miller? Okay, Commissioner White, you're recognized.
Thank you, Madam Chair. I just want to say that on the one hand, I can agree with what Commissioner Hagan is saying, but on the other hand, as I've said time and time again from this dais, that citizens deserve a choice in living styles, whether that be rural, suburban, or urban. And I've also stated multiple times from this dais that I believe that we should do a better job of having transitionary zones within the urban service area so that you have a logical transition from a suburban scale development into that rural area outside of the urban service area. I've also talked a lot about the population projections that are currently being worked on by our staff and Planning Commission and others. And, you know, the bottom line is, you know, depending on what type of land use policy this board sets and what our priorities are going to be and how we seek the most logical and at the same time efficient use of our land, we just might not be able to accommodate 500,000 more people. I mean, that's a possibility. If you look at the county like a fishbowl, you know, there are only so many people that this fishbowl can hold, depending on what we want our land use patterns to look like. When I look at the maps that were submitted today and in simply knowing the area like I do, I don't see compatibility in the request for 30 lots. The comp plan does indeed reference that compatible does not mean the same as. But as I see it, the existing allowance of 16 lots, while it's not the same as, it is compatible in my view. When I look at the proposal for 30 lots, I just don't see compatibility, and I see a scale of development that's too intensive. So for that reason, I'm not going to be able to support the motion on the floor.
Okay, thank you. Commissioner Miller, you're recognized.
Before we vote, let me ask a question again. I understand everything was approved in the Planning Commission and the hearing master. Let me call the applicant back up again. I truly don't know if there's anything you can work out with the citizens out there. But if we continue this, would you be willing to continue this at least to the next meeting and you sit down with the applicants and talk to them at least to see if there's something you can work out?
Absolutely.
Okay, I move a substitute motion that we continue this until the next meeting.
Great. We have a substitute motion by Commissioner Miller, seconded by Commissioner Kemp to continue item G1.
The date would be September 11th at
September
9 a.m.
11th would be the date. And is there any further discussion? Seeing none, please record your vote.
The motion carried 7-0.
Okay. We are now on item H1A and H1B.
H1A and H1B are related items. Commissioners, H1A is a rezoning that would otherwise be on consent if not for the related public hearing. H1A is a rezoning to allow for a multifamily project. It's related to affordable housing, and the application is consistent with the affordable housing density bump up. It's for 56 apartments and ancillary office. What's necessary, the critical piece that's necessary in this is the public hearing for H1B. It's, for all practical purposes, a clerical action to remove 7 parcels from the plan development that's on East Loki Lane, north of East 127th Avenue. It's modifying a plan development that was approved in 1981. So staff is recommending approval of this action, as well as the case that I referenced that would otherwise be on consent if it were not for this public hearing action. They can both be heard as one if you choose to, in terms of your motion. And we are recommending approval of both items with conditions.
Okay, thank you for that explanation, Joe. And we have the applicant here. Good morning.
Good morning, Madam Chairman, Commissioners. David Mechanic, Nucio, Hernan Wester, here on behalf of the applicant. I don't really have much to add beyond what Joe just described to you. We have a favorable recommendation from the hearing officer. We agree with all of the proposed conditions. The PRS that's before you is, as Joe said, really a housekeeping thing. There are several lots that are part of the proposed project that were originally part of another PD, so we have to go through the mechanical exercise of removing those lots from the old PD so that they can be included in the proposed development project for affordable housing. Be happy to answer any questions. Thank you.
Okay, thank you. I don't see any questions right now. We'll just open the public hearing on items H1A and H1B. Is there anyone here to speak in favor of items H1A, H1B? Anyone here to speak in opposition to items H1A, H1B? Okay, we'll close public hearing. Board action. Motion by Commissioner White, seconded by Commissioner Miller for items H1A and H1B. Is there any further discussion? Seeing none, please record your vote.
Motion carried 7-0.
Okay.
Commissioners, that concludes our agenda for today. The following 2 items were continued.
Yes. Okay, we do have a future issue. I was just going to ask if there was any other business. Commissioner White, you're recognized.
You know, we had a case just today, and I didn't want to say anything at the exact time because there was really no place for it in a quasi-judicial proceeding, and frankly, I didn't want to embarrass the applicant either. But we had a case just today where a land use change was sought to correct a mistake that had been made during development and/or construction, and I've noticed that multiple times, and it really pains me sometimes to see someone requesting a land use change to remedy an error that's been made, and that, if I'm not mistaken, that was a pretty large, kind of reputable builder and/or development firm. So how can we remedy that? Is it our staff that's checking the sites as they're being developed, or how can we get the word out that you can't just throw up a structure and then do something wrong and then come and just get a land use change granted?
So that particular item that was there today, that there was a error in the location of that structure on the site plan that was submitted with the building permit, at least the garage setback. We have actually just engaged with the building community in it's enhancing the way that we get those site plans. We've got a two-prong approach. One, to make that review process more streamlined and quick, but in doing that, we're getting a certification from a surveyor, architect, somebody who is putting some professional credentials to this site plan, and what that's doing is taking the burden and shifting that to a licensed professional versus a site plan being drafted for us to try to, for lack of a better word, catch those mistakes, because it's slowing our process down. It's slowing the process down for the builder. So this is something that we have initiated within the past several weeks, and we have got about a couple hundred permits that have gone through this process, and this has a higher level of attestation from the applicant, from a surveyor or architect, that plan is meeting the setback. So we think that will result in the event that these site plans were done with room for improvement on the due diligence, that we have incentivized that improvement and that higher level of review to get a faster result through us by more front-end work from the professional on the builder side.
Because it puts this board between a rock and a hard place. Absolutely. I mean, I don't think there's a member up here that's going to ask that a bunch of homes be demolished because of a setback issue. But at the same time, we don't want to send a signal to just go ahead and, quite frankly, build sloppily with respect to the design standards, and then you can just come in and get a remedy for it.
Yes, sir.
So, okay.
Okay, thank you. Commissioner Chris, you're recognized.
Thank you, Madam Chair. To expand a little bit on what was said by both Commissioner Hagan and Commissioner White, while I certainly understand the legalities that Commissioner Hagan was so eloquently orating, I agree with Commissioner White that sometimes, infill can be a bit of a shock to an area that may not be quite so urbanized. And while I have seen and experienced good infill in urban areas like the university area, and I know the economic opportunities that can be capitalized with the reduction of crime and the turnover of properties that are improved and what it could mean in turning blight around, the same kind of infill in a more rural setting, even though it's within our impact area, can be a bit of a shock. And I too would like to see a policy change that would provide for a transitioning so that it is less of a shock for infill to occur within those more rural areas of the urban service corridor.
Okay, thank you. Is there any other business come before us? Commissioner Kemp, you're recognized.
Thank you. I'll just comment on this discussion. I actually thought the transition area was what you were going to raise. I appreciate the other, but transition, I think that's the key word there. And I don't know that we have any basis for that in how we are moving forward. And so I think the thing to do would be to maybe bring this back from the Planning Commission with some recommendations about how we can look at those in the future, because some of those areas I notice are agricultural, and there's going to be requests for changes on our comp plan, and maybe we could have a category like that, because I think that's a good suggestion.
Actually, I've been talking with staff. I am bringing something back to the board. Orlando just changed their code to allow for diversity within the development plans that are brought to us. And so staff is looking at it right now. I've given them the information, and I'm going to ask them at our next board meeting that they bring a report back to us to show us how we could implement something like that here in this community. Yeah, it looked like a good plan. Okay, no other items come before us. We are adjourned.